There will be no need for anybody to take a note, because when I've completed giving this judgment, I will provide a definitive written version. So there will also be no need to create a transcript of the judgment. The definitive version will be the written version handed down at the end. Introduction. This judgment concerns the violation of an embargo on the publication or disclosure of the contents of a draft judgment provided in confidence to the parties and their counsel and solicitors. The draft judgment in this case was sent by the clerk to Lady Justice Nicola Davies on the usual terms to counsel's clerks at 1340 on 4th February 2022. Two of the three counsel representing the appellant were Miss Helen Mantfield, Queen's Counsel, and Mr. Mark Greaves, the barristers, who practiced from Matrix Chambers, brackets, Matrix. The email attaching the draft judgment was sent to the clerking team at Matrix. It included the following. This draft is confidential to the parties and to their legal representatives. Neither the draft nor its substance may be disclosed to any other person or made public in any way. The parties must take all reasonable steps to ensure that it is kept confidential. No action is to be taken, brackets, other than internally, close brackets, in response to the draft before judgment has been handed down in court. A breach of any of these obligations may be treated as a contempt of court. The header to the draft judgment itself included a statement in a substantially similar form, save that it expressly said that the practice direction supplementing CPR Part 40 applied to the draft judgment. CPR PD 40E, which establishes the procedure for circulating judgments to counsel for corrections, provides as follows. 2.4. A copy of the draft judgment may be supplied in confidence to the parties, provided that, little a, neither the draft judgment nor its substance is disclosed to any other person or used in the public domain. And, little b, no action is taken, brackets, other than internally, close brackets, in response to the draft judgment before the judgment is handed down. 2.5. Where a copy of the draft judgment is supplied to a party's legal representatives in an electronic form, they may supply a copy to that party in the same form. 2.6. If a party to whom a copy of the draft judgment is supplied under paragraph 2.4 is a partnership, company, government department, local authority, or other organization of a similar nature, additional copies may be distributed in confidence within the organization, provided that all reasonable steps are taken to preserve its confidential nature and the requirements of paragraph 2.4 are adhered to. 2.7. If the parties or their legal representatives are in any doubt about the persons to whom copies of the draft judgment may be distributed, they should inquire of the judge or presiding judge. 2.8. Any breach of the obligations or restrictions under paragraph 2.4 or failure to take all reasonable steps under paragraph 2.6 may be treated as contempt of court. At 1449, on the 8th of February 2022, brackets, the day before the draft judgment was due to be handed down in court, close brackets, Ms. Elizabeth Boucher, Senior Practice Manager in Matrix Chambers, brackets, Ms. Boucher, emailed a letter, brackets, the letter, to the clerk, to Lady Justice Nicola Davies, with the following text. It's been brought to my attention that our Matrix press release in relation to the judgment due to be handed down tomorrow on the matter of the Crown, Counsel General for Wales versus the Attorney General, has been uploaded too early. This was due to a miscommunication within Chambers, and we are very sorry for this vast administrative oversight. The text that was posted online is written below and was taken down immediately when this error was discovered. The Court of Appeal has dismissed the appeal of the Counsel General for Wales in his application for permission to seek a declaration as to the proper construction of the Government of Wales Act in the light of the UK Internal Markets Act. The Court of Appeal held that the application was premature and should be tied to a specific piece of Senate legislation. The Counsel General is seeking permission to appeal to the Supreme Court. Helen Mountfield QC and Mark Greaves represented the Counsel General with Christian Howells. Close quote, sick. The draft judgment was not included and has not been released. We apologise profusely to the court for this mistake and will take steps internally to make sure this error is never repeated. Counsel will be apologised to make our apologies in person to the court. I responded to the letter by writing to the barristers personally on the 11th of February 2022. I said that the letter had explained that the outcome of the case was made the subject of a press release from Matrix Chambers, posted, as I thought, on Matrix's website in violation of the court's embargo on the 8th of February 2022. I said that the court found inadequate the explanation that this violation had been, quote, due to a miscommunication within Chambers, close quote. I explained that the Court of Appeal, like other courts, operated on the basis of a system of trust between judges and counsel, and that adherence to judges' directions was central to that trust. Quote, it was counsel's personal responsibility to ensure that court's directions, square brackets, were adhered to, close quote. I referred to the strict provisions of CPR PD 40E. I sought a written explanation as to 1, what precisely went wrong within Chambers and how such a serious error could have occurred. 2, the names of each individual person within Chambers, whether barristers or staff, who had access to the embargo judgment and for what purpose they had such access. 3, who drafted the press release and posted it and where and for how long. 4, the precise steps that were proposed to ensure that there is no repetition of the mistake. Finally, I indicated in my response that we intended to hold a hearing at the earliest opportunity to hear oral representations as to what occurred and what consequences should follow. The barristers responded as directed by my letter at noon on the 14th of February 2022, providing the court with a summary of their responses to my questions and witness statements from each of the barristers and Ms. Bauscher. I shall deal with the contents of those statements in a moment. Yesterday, a further witness statement from Rachel Southern, Head of Marketing and Strategic Development at Matrix Chambers, was filed. We held the hearing that I had directed in my letter today, on the 16th of February 2022. It was attended by Ms. Mountfield QC and Mr. Greaves in person, notwithstanding that we gave the other counsel in the case, the solicitors and the parties the opportunity to attend. Only Diane Dunning, the solicitor within the Welsh Government Legal Services, actually did attend. I'm therefore delivering this judgment, having received written and oral representations as to what occurred and what consequences should follow. The barrister's explanation for what happened. The barrister's witness statements explain that once their clerks had received the password-protected copy of the draft embargo judgment, they were sent it and the password by separate email on the same day, Friday, the 4th of February 2022. Ms. Venetia Tate, a marketing assistant at Matrix, emailed the barristers at 10:09 on Monday, 7th of February 2022, headed, quote, news item, close quote, in the following terms, quote, I understand you are in court tomorrow for the case of Wales v. AG. Would you like a news item to be uploaded onto the website? If so, would you be able to draft some text, or shall we write something and send to you for approval? After that email, Ms. Mountfield drafted the text recorded above and sent it to Ms. Tate at 11:03 on Monday the 7th of February 2022. On the following day, Tuesday the 8th of February 2022, at 10:09, brackets which was still almost 24 hours before the hand-down fixed for 10 o'clock on Wednesday the 9th of February 2022, Ms. Tate emailed the barristers again, saying, "Would you prefer I did not post about it on social media?" Ms. Mountfield responded 1 minute later, saying, "I'm easy either way," and Mr. Greaves responded 2 minutes after that, saying, "I think it is probably worth posting on social media just due to the importance." At 10:30 the same day, Ms. Tate responded to the barristers, saying, "Thanks for confirming. I'll post on social media this morning." It can be seen immediately from this email exchange that the barristers each had 2 opportunities to realize that Ms. Tate, the marketing assistant in their office, was under a misapprehension as to the date of hand-down. On Monday, she had emailed saying that she understood they were, quote, "in court tomorrow." And on Tuesday, she had emailed saying she would post on social media that morning. The barristers were fully aware, and do not suggest otherwise, of the date and time of hand-down, which was, I repeat, Wednesday at 10 o'clock. To be fair to the barristers, however, I should record that Ms. Mountfield explains in her statement that she did not pick up, as she should have done, that Ms. Tate's understanding was that the date of hand-down was a day earlier than it actually was, because she was, quote, "working under pressure of time to get submissions to the court," close quote, and she, quote, "read and responded to Ms. Tate's email too fast," close quote. Mr. Greaves explains that he was engaged in urgent work and did not see Ms. Tate's original email, referring to his being, quote, "in court tomorrow," close quote. He replied to an email later in the chain without scrolling down to the email that had started the chain off. Neither of the barristers actually saw the email sent at 10:30 on Tuesday about posting on social media that morning until after the violation had come to light. The fact that busy barristers missed each of the 4 opportunities to avert a violation of the embargo highlights the need for chambers to operate far tighter systems if further such breaches are to be avoided in future. I shall return to this issue in a moment. It turns out that the press release that Miss Mountfield had drafted was actually posted on Matrix's website and on Matrix's Twitter and LinkedIn accounts at 10:29 on Tuesday the 8th of February 2022, and taken down some 5 hours later when Matrix was seemingly informed both by the Counsel General's solicitor and by Mr. Christian Howells, brackets the third counsel in the appellant's team, that no such releases should have appeared. Nonetheless, Matrix Chambers have some 14,000 followers on Twitter and more than 7,000 followers on LinkedIn who would have had access to the information. Because the tweet was deleted, there is no information about retweets. Miss Mountfield also described the normal practice at Matrix as being, quote, that when the practice team learns of a hand-down, they flag the fact, brackets, though not the content, of the judgment to the marketing teams. And a member of the marketing team emails the barrister concerned to ask if it should go onto the website, brackets, or quote, stroke, news feed at the point of hand-down. If so, the barrister is usually asked to draft some wording to be published on the website and social media following the handing down of the judgment. A revised practice has been initiated since this incident, but I do not need to record its details here. I should also record that both barristers have properly accepted personal responsibility for what occurred and apologise unreservedly to the court. Ms. Bauscher also filed a witness statement explaining what happened in the office and how Ms. Tate made the error about the date of the hand-down inadvertently, and despite the fact that the date was correctly recorded in the Chamber's hand-down log. The law. I've only been able to find 2 cases in which violations of an embargo on publication of a draft judgment have been in issue. In Bagent against Random House Group Limited, 2006, EWHC 1131 Chancery, the Lawyer magazine had published the result of a judgment on its website shortly before it was handed down. The posting was removed as soon as the error was discovered. Mr. Justice Peter Smith pointed out at 7 that the journalists in question were in ignorance of the law. At 12, he said that any future breach of CPR PD 40E might have quite severe consequences. More recently, and perhaps more significantly, in Her Majesty's Attorney General versus Crossland, to 2021 UK SC 58 Crossland, on appeal from 2021 UK SC 15, the appeal panel of the Supreme Court upheld the first instance panel's observations on the limited period of the embargo that had prevented the disclosure of a draft judgment. The majority of the appeal panel, Lords Briggs, Kitchen, Burrows and Lady Rose, held at paragraphs 63 and 77 that the restriction engaged Article 10 of the European Convention on Human Rights, but was necessary and proportionate. Quote, furthermore, the embargo, was for the specific purposes of enabling the parties to make suggestions for the correction of errors, prepare submissions on consequential matters, and to prepare themselves for the publication of the judgment. It is important that the published text of a judgment of the court should be accurate, complete, and in its final form. This restriction was clearly necessary in order to achieve the legitimate objective of maintaining the authority of the judiciary and judicial decisions, and was a proportionate means of achieving that result. Close quote. These comments apply as much to that case as to this one, and to draft judgments handed down in the Court of Appeal under CPR PD 40E as to the equivalent process in the Supreme Court. Discussion. The events I have described should not have happened. The Court understands that mistakes are bound to occur, and that is why, if the strict rules contained in CPR PD 40E are to be adhered to, far stricter measures need to be put in place by anyone who is given the privilege of seeing an embargoed draft judgment before it is handed down and thereby put into the public domain. I should say that I have called this case into court because, amongst other reasons, the breaches that occurred here are not alone. I have become aware, formally and informally, of other breaches in other cases. It seems, anecdotally at least, that violations of the embargo on publicizing either the content or the substance of draft judgments are becoming more frequent. The purpose of this judgment is not to castigate those whose inadvertent oversights gave rise to the breaches in this case, but to send a clear message to all those who receive embargo judgments in advance of hand-down that the embargo must be respected. In future, those who break embargoes can expect to find themselves the subject of contempt proceedings, as paragraph 2.8 of CPR PD 40E envisages. I want also to draw attention to the terms of paragraph 2.4 of CPR PD 40E, which provides that a copy of the draft judgment may be supplied in confidence to the parties, provided that, quote, A, neither the draft judgment nor its substance is disclosed to any other person or used in the public domain, close quote, and B, no action is taken other than internally in response to the draft judgment before the judgment is handed down. The person to whom the judgment is normally, brackets unless specific protections are provided for, close brackets, supplied, are counsel, the solicitors working on the case, and the parties themselves, brackets, whether individual or corporate, close brackets. Paragraph 2.5 of CPR PD 40E envisages that a party's legal representatives may supply a copy to the party, to the claim, in electronic form, not that it can be circulated elsewhere. If the party is a partnership, company, government department, local authority, or other organization of a similar nature, paragraph 2.6 of CPR PD 40E provides expressly that, quote, additional copies may be distributed in confidence within the organization, provided that all reasonable steps are taken to preserve its confidential nature and the requirements of paragraph 2.4 are adhered to, close quote. This is not a license to circulate the draft judgment beyond those who need to see it for the purposes for which it has been distributed in draft. It is important, therefore, to understand why judgments are handed down in draft under embargo in the first place. Some insight is gained from the passage cited above from Crossland. That suggests that the process is to enable the parties to make suggestions for the correction of errors, prepare submissions and agree orders on consequential matters, and to prepare themselves for the publication of the judgment. The process is not for any other purpose, and dissemination of the judgment itself or its substance beyond those that I have specifically mentioned is forbidden, unless the court expressly gives consent. For a fuller explanation of the history and rationale of the court's practice, see Woods, paragraph 168, a cautionary tale concerning the circulation of draft judgments to counsel, 2017, Oxford University Comparative Law Forum. In this case, a number of specific errors were made. First, it was not appropriate for persons in the clerk's room or offices of chambers to be given a summary of its contents. That was not necessary for any of the purposes I have mentioned. The clerk to the barrister in question is sent the draft judgment for onward transmission to the barrister. And whilst I accept that nobody in Matrix's office actually read the draft judgment, they were sent a press release explaining its contents, which should not have happened, as I shall explain in a moment. There would be nothing objectionable about a clerk transmitting corrections, submissions, or draft orders to the court, but that again is not what happened in this case. Secondly, drafting press releases to publicize chambers is not a legitimate activity to undertake within the embargo. It would be different if a corporate party wished to issue a press release immediately on hand down to explain to the public what had occurred in the judgment. But barristers and solicitors are not parties to the proceedings. They are legal representatives who are provided with the draft judgment to make suggestions for the correction of errors and to prepare submissions and agree orders on consequential matters. They have no need to prepare themselves for the publication of the judgment, as an individual or other party might need to do. Of course, counsel and solicitors can properly assist and advise their client to make such preparations, but that was not what happened in this case. Thirdly, too many people in Matrix seem to have had access to the summary contained in the press release. It should be sufficient for one named clerk to provide the link between the court and the barrister or barristers. Nobody else in the chamber's administrative machine should have access to the draft judgment or any of the documents created in relation to it without there being a good reason connected to one of the permitted purposes I have mentioned for them to do so. Finally, the measures taken by Matrix to protect the confidentiality of the draft judgment and its contents were lax. The barristers either did not read or did not properly read emails they were sent in relation to the draft judgment, and no proper precautions or double checks were in place to ensure that one employee's error came to attention. I don't wish in this judgment to suggest what level of security is needed, but whatever is done must be effective. Each of paragraph 2.4 of CPR PD 40E, the standard rubric on draft judgments, and the standard form email sent out with draft judgments are in mandatory form. The latter two documents say that, quote, the parties must take all reasonable steps to ensure that it is kept confidential, brackets, emphasis added. As I've already said, paragraph 2.4 of CPR PD 40E provides that, quote, neither the draft judgment nor its substance is to be disclosed to any other person or used in the public domain, close quote, and, quote, no action is to be taken other than internally in response to the draft judgment before the judgment is handed down. Counsel and solicitors are personally responsible to the court for ensuring that these mandatory requirements are adhered to. It is their duty to explain those same obligations on the parties to their clients. Conclusions and summary. As I have tried shortly to explain, the provisions of CPR PD 40E are mandatory. It is the personal responsibility of counsel and solicitors instructed in a case in which an embargoed draft judgment is provided to ensure they are complied with. The purpose of the process is to enable the parties to make suggestions for the correction of errors, prepare submissions and agree orders on consequential matters, and to prepare themselves for the publication of the judgment. CPR PD 40E exists for good reasons. The consequences of a breach of the embargo can be serious. It is not possible to generalize about the possible consequences, as judgments will range, for example, from dealing with highly personal information in some cases to price-sensitive information in others. The court is rightly concerned to ensure that its judgments are only released into the public domain at an appropriate juncture and in an appropriate manner. My conclusions are as follows. 1. It is not appropriate for persons in the clerk's rooms or offices of chambers to see the draft judgment or to be given a summary of its contents. 2. Drafting press releases to publicise chambers is not a legitimate activity to undertake within the embargo. 3. It should be sufficient for one named clerk to provide the link between the court and the barrister or barristers. 4. Proper precautions and double checks need to be in place in barristers' chambers and solicitors' offices to ensure that errors come to attention before the embargo is breached. And 5. In future, those who break embargoes can expect to find themselves the subject of contempt proceedings, as envisaged in paragraph 2.8 of CPR PD 40E.
I agree.
I also agree.
Well, Ms. Mountfield, that concludes the hearing. I can hand out a...
Just the formatting of paragraph 1 appears to have gone
Well,
wrong.
I'm going to hand this out because there is nothing, there is a little bit of formatting and there's a couple of very minor typos that I noticed in reading it out. And I will ask my clerk to circulate a final electronic version in a few minutes, and that will be the one that goes to Bailey and so on. So thank you for your submissions, and thank you to both Mr. Greaves and Ms. Dunning for attending and your courtesy in dealing with this matter.
Court rise.